SABC, together with the Department of Justice and Constitutional Development, bring you the final verdict. In the pursuit of justice, we are all equal before the law. These are some of the stories that have led to the final verdict. At the end of a criminal trial, if either the state or the accused feel that the conviction and/or sentence was unfairly arrived at, then that party has the right to apply for leave to appeal to a higher court.
When a court has made a decision in a criminal case, for an example, the state or the accused has a right to take the matter on appeal, which is, I want to take this decision to a higher court to find out whether the decision itself is correct. I contend the decision is wrong. Sometimes an accused person might decide, okay, well, I'm not going to dispute that I'm guilty. However, I think 25 years is too much. So I will go and appeal and ask a higher court whether, considering what I was charged with and the facts that unfolded in court, whether a 25-year sentence is appropriate. Appeal always works upwards, so you always go to a higher court. So from a magistrate's court, you would go appeal to the High Court. The Supreme Court of Appeal, which sits in Bloemfontein, is what we call the last court on all matters that do not involve constitutional issues. So when a case has been decided by the Supreme Court of Appeal, that is the end of it. There is no further to go.
Luyanda Kulu and his girlfriend Linda Bala had been dating for 2 years when the relationship ended. This triggered a series of events that would devastate an entire community.
The whole street was cordoned off, and there were just so many policemen and very senior provincial policemen, which made me realize this is not just another murder.
6 months after the breakup, Luyanda went to Linda's home with the intention of killing her. Linda wasn't home, but tragically, 3 other people were, including a 2-year-old child. Luyanda killed them all with a butcher's knife and then waited for Linda to return.
I went back to the crime scene the following day, and then the policeman let me inside. And nothing could have prepared me for what I saw in there. The bodies have been removed at that point, but the blood was still there. And it was just absolutely horrific. It's something that I wish I never saw. I just remember seeing stab marks even in the doors and on the walls, and the blood splattering and the amount of blood made me think that this person couldn't have been in the right state of mind when he did this. I was a young journalist then, and I could identify with the room because it was a young girl's room. I still remember seeing her shoes and the little pink young girl things. And that was just so harshly contrasted with this horrific crime scene that you couldn't fathom that something like this happened. Tied her hands to the bedpost, he tied up her feet with cable ties, and then he stabbed her in the chest. After that, I moved into the corridor again and then to the last bathroom. That to me was the worst because that's where the young mother and her baby were killed, her 2-year-old boy. It did affect me badly. The images are still with me, and I really wish I never saw that.
Overkill is very often a sign of an interpersonal motive for committing that crime. There's an anger towards that individual, because most knife murders, for example, in South Africa, only involve between 2 to 3 stabbings. So as soon as you get sort of 5 and upwards, you're dealing with more than the norm. And what can we decipher from that more than the norm figure of stabbing? So in this particular example, for the main deceased, the girlfriend who was murdered, she had 14 stab wounds. So automatically we would say that's overkill, most likely you're dealing with someone who had a personalized motive to kill that individual.
Luyanda was convicted of 4 counts of murder in the Regional Magistrates Court, but the sentence created great controversy.
On count 1, the murder of Linda Bala, the accused is sentenced to 15 years imprisonment. On count 2, the murder of Yandi Fuchani, the accused is sentenced to 15 years imprisonment. On count 3, the murder of Thomas Ngewu, the accused is sentenced to 15 years imprisonment. On count 4, the murder of Paki Fuchani, the accused is sentenced to 15 years imprisonment. The sentences are to run concurrently.
The magistrate gave Luyanda a light sentence for the murders because she accepted the defense's argument that he was obsessed with Linda and that the psychological effects of the breakup served as a convincing reason to depart from the minimum sentence for murder.
That's 60. You got 60 years.
No. I'm so sorry. The sentences are concurrent. They run simultaneously. It's only 15 years in total.
For all 4 murders. But you deserve to rot in jail, man. What is wrong with you people?
It's okay. It's okay. I've got it. Listen. SABC, listen to me. It's not over. We'll appeal the sentence to the High Court. We'll get justice. This is not the end.
When somebody is facing more than one charge, at the end of the trial, a court has to take a decision in respect of each charge. There is a requirement that each one must attract its own sentence. The court then has a discretion to decide whether each of the sentences is going to run on its own, which would mean consecutively. You serve one, you finish. As soon as you finish, you start your next, and so forth it goes. Or whether they are going to run concurrently. When they run concurrently, it means from the first day you are in prison, you are serving the first day of each sentence. So they all run at the same time.
The court will order that a sentence run concurrently if, when it looks at the facts of a particular case, they look at how closely linked the offences are that the accused is convicted of. In the case of multiple murders, if it happened in the same location, he, for example, used the same weapon, the intent at the time was more or less the same because he wanted to achieve a particular goal, the court would think of ordering that the sentences run concurrently.
Normally when the prosecution takes the matter on appeal, normally we say it's the state taking the matter on appeal, it is usually as regards the sentence. That is more common than not. And the basis for instituting appeal would be that the sentence is shockingly inappropriate, as we term it, which means it is too little.
I've covered many court cases, you know, so I had an idea of the sentence that's usually given for murders like these. And it was just unbelievably light. I couldn't believe it. I can remember the victims' family members who were in court, the parents, they burst into tears.
In this particular instance, the prosecution did take the sentences on appeal because, and I agree with them, it was quite shockingly small or little for the crimes that were committed. And I think that's to the credit of our justice system that decisions can be taken on appeal to a higher court.
You know, a sentence can't bring a loved one back, but somehow an unfairly light sentence adds to the grief.
Coming up, the sentence is taken on appeal to the High Court in a battle for justice.
I beseech the court to consider the entire community out there who are still waiting for justice.
The Criminal Law Amendment Act 105 of 1997 provides for minimum sentences to be imposed in cases where an accused is proven to have committed certain types of serious offenses, including premeditated murder. The court that decides the appropriate sentence can only depart from the guidelines set out by the law where there are substantial and compelling circumstances which allow it to do so.
The rules governing minimum sentencing in South Africa is governed by the Criminal Law Amendment Act. What it does is it places an obligation on the presiding officer, whether it be a magistrate, whether it be a judge, depending where the trial is heard, to impose certain minimum sentences for certain offences. For murder, in particular types of murder, certain circumstances must be present. You can receive life imprisonment.
If you go by that, he should have had 4 life sentences. But the judge said in his sentence giving that there was compelling and substantial circumstances, and that's why the minimum sentence wasn't served.
The Act itself sets out strict requirements that must be met as to when the court may depart from the minimum sentence. So when the court wants to depart from that, it must first of all find that there is substantial and compelling circumstances present which justify a departure from those prescribed sentences. The Act does not set out exactly what is defined as compelling and substantial circumstances. Hence, it differs from presiding officer to presiding officer. It depends on the facts of a particular case.
Peter, I want to testify. I need to tell the judge about Linda, how much she meant to us. So as I go now,
SABC, I cannot imagine what it's like to lose a child. And the way that you found her, I'd probably lose my mind. But unfortunately, the court does not hear witness testimony in an appeal case.
How will you make it?
Wait. That doesn't mean the judge won't hear what you have to say. I've just realized something. Do you remember writing your statements before the last trial? Your victim impact statements?
Of course, we all did. Our whole family.
But I don't think they were read.
Exactly. Those statements can take a while to process. I didn't think they were taken into consideration.
But how will that help?
I may not be allowed to bring in any witnesses or introduce any new evidence, but I can emphasize evidence that may have been, let's just say, unappreciated during the last trial. The impact that the murders had on your family. That was not properly taken into account. That's our angle.
The appeal proceedings are different from the trial court, in that in a trial court, all the witnesses come to court and they give evidence in a box, they are cross-examined. The accused may elect to give evidence or not to give evidence, but that is the standard process for a trial court. On appeal, however, there are no witnesses. What the court does sitting in appeal is to work off what we call a record. So every trial is recorded, and if the case is being appealed, that record must be then typed out from beginning to end. The court sitting in appeal deals with the record as is written. It then hears argument on behalf of the state and on behalf of the accused. But there is no further evidence that can be led on an appeal unless there are exceptional circumstances. But it's very uncommon. It's possible, but uncommon.
Tea or coffee, Mr. Gardner?
Please, call me Peter. Tea, please. Again, I'm so sorry that I'm late.
No, you're a busy man, I understand that. But let's get right down to it, shall we?
I'm all ears, Father.
I know you want us to talk about the effect these murders have had on Linda's family.
Yes, I spoke to the family the other day.
But that's just it.
That's just what, Father?
Yes. Linda's murder alone was more horrific than any of us could have ever imagined. But, Mr. Gardner, it's not just Linda and her family who were affected. There were 3 other victims, all of them members of this church.
I didn't realize that you were familiar with the other victims.
not just the other victims, the victims' families, their extended families, their friends, colleagues. Do you see what I'm saying?
Yes, I think I do.
An entire community spirit have been shattered. I have had nearly 80 individuals approaching me with their concerns over these incidents. Probably more.
80? That's unbelievable. I've been so myopic, so focused on the case.
Everyone was. You've been doing your job, Peter. Feelings and emotions tend to get in the way.
The main reason that we take in this case an appeal to the High Court is that the Magistrates' Court failed to take into account the impact that the crimes had on the victims' families. But now I see that
it affected all of us.
Any victim is a member of a community. So when the perpetrator, the accused, harms that victim, it impacts on that victim and that victim's family, but it also impacts on the greater community. If a murder is committed by an accused, it means that fear is instilled also in that community, fear that he may well commit another murder.
What's always traumatizing for a journalist is to interview the family members after the murder. I spoke to the young girl's father the day after the murder, and I've never seen a grown man cry like that. He was just so overcome with grief, and he just kept saying, my beautiful child, my lovely child.
Coming up, will the community receive justice for these senseless murders?
The least we can do for the victims is to recognize this in the sentence imposed on the respondent.
My lord, if you look at page 72, you'll see the testimony from a clinical psychologist that my client was seeing. It states very clearly that my client was experiencing severe symptoms of manic depression when he committed the crimes. Then, on page 73, there are love letters written from Linda addressed to Mr. Kula. In one she writes, and I quote, "I could not live without you."
I can see this, Miss Lewis, but what must I do with it?
My lord, Linda blatantly misled my client into believing that she was in love with him and...
Miss Lewis, please don't waste the court's time with speculation about teenage emotions.
As the court found, Mr. Kula is a very sick man. Now, we're not blaming the deceased, far from it. But these letters, combined with his mental illness, was enough to push Mr. Kula over the edge.
And you believe this to be enough of a mitigating circumstance?
Yes, my lord. I submit that Mr. Kula's mental state was more than enough of a mitigating circumstance. The court who tried him found it to be so as well, as I submit would any court.
Sentencing is always, I suppose, a very difficult part of any court procedure, whether for the presiding officer, whether for the prosecutor. But when the court, there are set traditional factors which the court must look at. He must look at the personal circumstances of the accused. He must look at the seriousness of the offense, and he must look at the interest of the community. The court must also look at the particular circumstance of that particular case to determine, are there aggravating factors? Are there mitigating factors which mitigate in the favor of the accused? So that at the end of the day, what you have is a balanced sentence where the punishment basically fits the crime.
My lord, the state submits that there was a critical oversight during the previous trial.
Go on.
Ms. Bala was not the only victim on that fateful day. There was not one or two, but 3 other people who were murdered by the respondent. 4 lives, 4 innocent lives were taken that day, and all in the name of what? Jealousy, rage, a bout of depression. Who of us haven't been jealous or vengeful or depressed? None of us could deny that. And on some faraway plane of reality, it is even conceivable to us that if we were pressed for the truth, we would have to admit that punishing the person who hurt us would bring us some level of satisfaction. But the state submits that it is not
under any circumstance conceivable to the rest of us, to hurt innocent bystanders in the pursuit of punishing the one person who hurt us. My lord, the magistrate in the trial court failed to take account of the profound impact that these crimes had on the family members and the wider communities of the victims of the multiple murders committed by the respondent. The point is, my lord, the file in front of you contains dozens of letters written by the community who were grossly affected by these multiple murders. I submit now that these letters are much more important than any mitigating circumstances brought forward by the defense. I beseech the court to consider the entire community out there who are still waiting for justice.
When a court sentences an accused for a crime, the court must take into consideration a number of factors. The most important is that a community has a right to be protected from criminal conduct by other persons. When we consider conduct abhorrent, it must translate to the sentence. That is a message by society to say, this we shall not stand for. So a sentence serves two purposes. It really is to punish the accused for what they have done, but also to send a message to everyone else that we will not stand for certain conduct.
In respect of these 4 senseless murders, the court below did not pay sufficient attention to the ripple effect these offences had on the wider community. The least we can do for the victims is to recognise this in the sentence imposed on the respondent. In respect of count 1, the murder of Linda Bala, the accused is sentenced to life imprisonment. In respect of count 2, the murder of Yandi Fuchani, count 3, the murder of Paki Fuchani, count 4, the murder of Thomas Ngewu, the accused is sentenced to 20 years imprisonment in respect of each count. The respondent is hereby sentenced to life imprisonment.
In this case, the appeal court found that the magistrate's court had overemphasized the personal circumstances of the accused without sufficient regard for the seriousness of the offense and the interests of the community.
I think our justice system has checks and balances, such as the appeal or the review process, if there's some dissatisfaction with how a decision was come to or the final decision that was made. And I think here the system, although we didn't from the start get the sentence that I think was appropriate, the mechanism was there that allowed us to have it taken on appeal and argue that it was inappropriate and have an independent body look over it and say, yes, we agree that these were not the correct sentences. We feel that a heavier sentence should be imposed. So I think that, again, is a credit to how our justice system does work.
The justice system provides a safety net by allowing for appeals to a higher court in cases where one of the parties believes that the case was wrongly decided. If a court departs from the minimum sentencing laws, there must be substantial and compelling reasons allowing it to do so. When determining an appropriate sentence, the courts consider the personal circumstances of the accused, the seriousness of the offense, and the interests of the community. The final verdict was brought to you by SABC together with the Department of Justice and Constitutional Development.